My name's Roger Citron, and I'm an associate dean and professor at Touro Law Center. And tonight, I'm delighted, really, to have as our guest on the Touro Law Review podcast, Martin Siegel, who is many things. He graduated from Harvard Law School back in 1991, practiced law for many years, still practices law, is also an adjunct professor at the University of Houston Law Center or Law School. And what we'll be talking about tonight is that Martin Siegel also is an author. He's written a marvelous biography of Judge Irving R. Kaufman, who, as we all know, and we'll discuss tonight, as a very young trial court judge, federal trial court judge, tried the very famous Cold War espionage case, the United States versus Rosenberg, and that would be both Julius and Ethel Rosenberg. I should stop to let you get a word in, Martin. Let me start with a question, which is that you clerked for Judge Kaufman, and you went in that sort of eyes wide open, knowing that he could be a difficult judge to work for. Can you say a little bit about, the application, the interview, and then what the experience was like clerking for him?
Sure. Yes. Well, thank you. Let me start by just saying thanks so much for having me on the podcast. I'm really delighted to be here and to talk about the book. So it's right. I was one of his last two law clerks, and my co-clerk and I, was a law school classmate of mine, although I didn't know her at school, started in the summer of 1991. She started about 2 months before I did. And so the job was supposed to be 91 to 92. As it happened, Judge Kaufman died in February of 1992. So while we were there, and in my case, that means I clerked for him for about 6 months. And it's also true that he had a reputation, well-deserved, as a difficult taskmaster and a hard guy to work for. I, in the course of researching this book, I talked to about 50 or so former clerks, and they confirmed, that in spades, I would say. So what about it was difficult? Well, he was rarely satisfied. In fact, several clerks told me that when they started the year, they would hand in their first assignment. It might be a draft of an opinion or something like that. And, you'd leave the office, he'd wait a few minutes, then he'd buzz you back in. He had a system of buzzers, where he would buzz the clerk and you had to get in there immediately. And you'd come in and he would have crumpled up your first opinion and he would throw it at you. And he would say, "This is blank." And the blank was usually an expletive of some kind, but it was not flattering. And more than one clerk was so flustered by that, that it became almost a ritual. Then they would call up a prior clerk and say, "Oh my God, this happened to me. What do I do? I'm not sure I'm cut out for this." And the former clerk would put them at ease and say, "Oh no, this happens every year. You just need to go back to that first paragraph or so and change some words and hand it back in, make sort of superficial changes." And that usually worked. That would sort of mollify him. And it would often go like that for the first several months of the clerkship. It usually got easier as it went along. And all of that was probably, or so most of the former clerks theorized, a sort of expression of some insecurity on his part. He was afraid that these new clerks would embarrass him in some way, or do something that like a wrong result or an opinion that didn't sound good or something like that he didn't catch in his own editing. And as the year went on, he gradually understood he could sort of rely on their work. Usually his hiring had found the right people who would do jobs that were good enough. And so the pressure kind of abated, but he could be belittling. He could be personally needling. If you went to Harvard, he hired from Harvard probably more than any other law school, and he would call you Harvard. And he would, a couple of clerks said, he would yell at them and say, "I went to Fordham and I know more law than you do. You went to Harvard. How could that be? Or how did you make the Harvard Law Review?" That sort of thing. He could really attack you at a kind of personal level and find what insecurity you might have, and kind of drill away at that. The hours were quite long. He would leave the office and then he would call back into chambers at night and expect you to be there. He when he gave you an assignment, there was no sort of period when in his head you were doing it. It was more like a few minutes would go by and he'd call you, get you on the phone, if he was home, or he'd buzz you back into chambers and he'd say, well, what's up with that? Have you done it? And he said, well, Judge, you just gave it to me. I'm trying. He's like, well, get it done. He was hyper efficient in his own way of working and in his own management of the courtroom as a trial judge. And that sort of trickled down to those who worked for him, sort of for better and for worse. So in talking to these ex-clerks, I would say that the dominant experience that they relayed to me was that it had been a very difficult year, and many of them had come away from it with no great fondness toward him personally. But I would say most said it had been really valuable training. It prepared them for what was often the kind of rough and tumble or even cutthroat world of being a lawyer at a large firm, typically in New York. So you asked, in a way, maybe you're quite getting at this, but I've been asked before in connection with events for this book, why would I go work for him knowing how difficult it was? And the short answer to that is he was the only federal appellate judge who offered me a job. So I wanted to be in New York City and I wanted to work on an appellate court. And so he was it. And I didn't see all that much of the famous Kaufman treatment as it happens. And that's because over the time that I was there, he was gradually getting more and more ill and more detached. So there were a couple of episodes where he yelled at me, and I remember yelling at me over the phone once for something. And he'd hurt his arm in a trip he'd taken over the summer before the fall sittings, and his arm was in a sling. And so I was trying to help him with this robe and get the robe kind of over the sling, and that wasn't going very well. And that was this sort of episode that discombobulated him, and he would start yelling at you. So he's one of those bosses. We sometimes we encounter them, and we've all heard about them, and he was one for sure.
One of the things I was struck by, this is just a small part of the book because, you tell, the entire story, the life story, but that you actually seem to get along with him fairly well, and for the most part. And do you have any sense of whether that was just in some ways the chemistry between you two, the circumstances of the clerkship, the fact that he may have been a little bit older, a little bit sort of preoccupied with his health issues? Or
maybe so. I don't think it's because he was older. The clerks before the two of us told me some really, really crazy stories. One of them was a woman, and she got yelled at by him so often that she would she couldn't handle it really, and she would often cry in chambers, and then she would go to the bathroom and try to cry there, get sort of away from the judge. And the judge learned that she was in the bathroom, eventually would ask her co-clerk, where is she? And the co-clerk said, well, she's in the bathroom. And so he got in his head that she must be drinking too much water. So he banned water from chambers. So he was 80 at that point. It was right before we started. So he was every bit as cantankerous, at the end. I think, to answer your question, I got along with him pretty well, largely because he was he was ill and stopped coming in and just wasn't as active. So I think I really only saw sort of a shade of the real person, and even that only for 2 or 3 months. Now, having said that, we did, in that interaction, we did get along okay, and it helped. And former clerks told me this as well. Former clerks have really faced more of it than I did. It helped to know that, this is just how he was, and it wasn't really personal. He did this to everybody. And of course I think everyone knew that going into the job. You can know that. But if you can find a way to truly kind of internalize that, and which is harder for some rather than others, maybe, that helped, I guess. He did have a sense of humor. He could be charming when he wanted to be. My interview with him, he was extremely charming. And a few clerks told me that as well, that although that was a rare experience for them to which were much more common in other clerkships, I think, to sit around in the chambers of your judge on a Friday afternoon and hear old war stories and sort of be relaxed. He didn't do that very often, but he could when he wanted to, and so it was there. It was there, just not brought out very much.
And then this, I think, goes to the heart of the book, but I wanted to sort of ask it in the context of this time frame when you were working for the judge. And this is his life story, as you document so well, is this extraordinary immigrant story.
Yeah.
It's I'm even reluctant to say it because I don't even want to diminish from it, but right, it's sort of a Jewish Horatio Alger story from the first half of the 20th century. He launched himself to greatness on his own.
Yes, yeah, that is really true. That's really true. It's just a exemplification of that slice of history that we all hear, and we know that a lot of other people, a lot of other families accomplished as well, which is to start with nothing. His parents, got to America by 6 years before he was born. This immigrant family, Lower East Side. Then they moved to Jewish Harlem. His father died when he was relatively young. And so you're right. What he achieved, he did on his own through dint of extremely hard work, extreme focus, and of course all the sort of levers that were out there at the time in New York for someone to use if they could. For in his case, Fordham. Fordham gave him a place to go where not its campus up in the Bronx, but something relatively new they'd started called Downtown Fordham in the Woolworth Building. And that was a place that didn't only cater to Catholic students in New York. It took a lot of Jewish kids. It took a lot of kids who needed night school, although I don't think Kaufman went to night school as far as I could tell. But a lot of the kids there did go to night school because they had to work during the day. Took a lot of women during World War I when men were gone. Took African Americans. So it was a real melting pot, and it was Fordham's effort at sort of outreach into the city, and he benefited from that entirely. And it was almost cost free. I mean, it wasn't CCNY; it wasn't completely free, I don't think, but it was very low cost. And he raced through it. I mean, he didn't want to be there long, so he was in this combined program where law school and college altogether took 5 years. So it's basically 2 years of pre-law undergraduate work at Fordham. And then he was out earning money, which he needed to do. But he was always in a hurry. I mean, he finished law school before he could even take the bar exam. And in a classic Kaufman move, he tried to go around that rule and find some way to circumvent it through a personal connection to the chief judge of New York at that time, who tried to this friend of Kaufman's tried to intercede with the chief judge and waive the rule. And the judge said, tell the young man to slow down. A few months will do him good. And that's what I was probably the last time that he found a rule he couldn't circumvent.
It's a great story. Including that exact quotation, which I know you have in the book. Going back to just when you worked for him, did you have that sense of him? In other words, that he was, or was that something that it was in some sense in the past for him and who he was and how he presented and so on?
Yeah, I think it's a really great question because it's not something I'd thought about before I started working on this book, and I hadn't thought about it because it didn't come up at all in my clerkship. Not only did it not come up overtly in the sense that we discussed it or I heard it discussed, but as a person, he didn't in any way exude that kind of background or that kind of life journey or family journey in the way that you sometimes get that from people even before they might give you the particulars. He was not like that. And so much so, and relatives have told me this as well as some law clerks who became closer to him in later life. So much so that I think it was deliberate. I really think there might have been an element of embarrassment at his sort of humble origins. And I think that's also, it plays into what seemed to be this kind of insecurity over his educational background as well. I mean, he was surrounded by on the on the bench and at the upper echelons of law in New York. He's surrounded by Ivy League graduates, and he only hired from Ivy League schools, which was not at all unique. His colleagues, for the most part, only hired from Ivy League schools. And there was always a sense that maybe he was a bit intimidated by his slightly more humble sort of educational background. He certainly did very well financially, both through his own a period when he was in private practice in the 1940s, but also through his wife's family, who amassed a fair amount of money through real estate transactions and through the ownership of parking lots in New York City. That provided a kind of ongoing stream of revenue as New York became more and more dense and more crowded, and parking lots became, more and more profitable and at a premium. So the family benefited from that. They did well, and he lived on Park Avenue in a very nice apartment. And I just don't think he wanted, I think that sense of being sort of unpolished and of very modest means was something he didn't want to convey to the world. I think he wanted the world to see him after he'd arrived on the Upper East Side in Park Avenue, at the top level of his chosen profession, one small step away from the very pinnacle on the Supreme Court. And so I never found, in all of his writings and his personal communications, I only found one reference to it, just one, and that, which I can read if you don't mind, because I really think it's kind of a key to him, or at least a key to his later jurisprudence. It's a note or a sort of draft, would be a better way to describe it, a couple of pages that are in his papers, and it reads as if it's a speech you might give or remarks you might give after his appointment to the district court in 1949, at a reception, you might imagine. And it was relevant to me both because of the content of it, which was so unique, set apart from all the other things I found in his papers, and because it was at a time when he would have written it himself. He didn't yet have law clerks and a phalanx to kind of draft his law review articles and his speeches, which was very much the case in later life. This is something he would have written himself. So he said, "As I look around, my mind goes back to my early youth, the son of immigrants, and I promise you and all my other friends that I shall endeavor and hope to be privileged to make it a lot easier for those who are now struggling like I did 20 years ago. Only in such a fashion can I reward the faith placed in me by this great distinction." And he never in any other remarks that he gave or any other private correspondence of his that I found, or even references, within the family correspondence, that sort of thing, did I see any reference to struggling as a young man, to being disadvantaged, to being the son of immigrants. None of that was present. So that's why that really stood out. And I think, to come back to your question, he gave no sense of that at all. I think he didn't want to.
Yeah. When I know you're an experienced attorney. So did there come a time when you decided to write a biography of the judge for whom you clerked?
Yeah, I love the phrasing. Did there come a time? You don't want to ask a leading question. Yes, there did, and it was almost instant. I have to say, it was almost instant. I was sitting around in chambers, and I had that really unusual experience that a small handful of clerks have, I guess, every few years, where the judge they were working for has passed away. And so I'm just sitting in chambers, sort of nothing to do. My co-clerk got reassigned almost instantly to a district judge whose clerk, also a classmate of mine, had fallen ill, and he said he needed extra help. So my co-clerk was gone within 24 hours, and I'm just sitting in chambers. And a week or so later, the guy from the Library of Congress comes to survey the papers, because he'd already made provision for his papers to go to the Library of Congress. And I just thought, probably it was that guy's visit that had me thinking about the history connected to him, and the fact that he was a figure worthy of his materials being memorialized at a place like that and kept for later research. It just had me thinking that he was worth a biography, and that his even aside from the Rosenberg case, and that his sort of personality and his nature made him a fascinating figure to me. This kind of mixture of good and bad, of personality traits, like how difficult he could be to work for, and as I later learned, and there was even some inkling then that bled into his family life, ways in which his personality was so irascible and so hard, and yet you know, sort of the success he'd achieved, and not just the his own sort of climb up the ladder, but the significance of his work. Again, aside from the Rosenberg case, not just the Rosenberg case, because there's been a lot written about the Rosenberg case, and that alone, I think, certainly would not have merited another book. But yeah, I was interested from the get-go, I would say. Took a long time to put it into practice, but the interest was there.
Really, you could, at least you finished, right? I mean,
yeah, right, exactly. I
did
finish. I started early and finished. I mean, I began this in 1994. I began this only 2 years after he died. After my first job as an associate, I had some time between jobs and began doing research. So it's dribs and drabs over the years, and then finished in the last few.
And then this, you referred to his personal life, his family life, and one of the things that was really revelatory in the book was that you were able to describe his personal life, at the marriage, his what he was like as a father, in some detail. And I guess the first question I wanted to ask is, on that front, was how did that come about? And if you could just say a little bit about just exactly that.
Yeah, sure. Well, my main connection was to one of his grandchildren, one of his grandsons, who's in his 50s now, roughly my age, a little younger, but not by much. And I had not quite a connection, but I knew where he lived, and I knew someone who was close by, and I just had a sense that there might be some family connection there, and sure enough, there was. This is in Westchester, and that was a kind of entree to him. Otherwise, I didn't have his contact information. I'd never communicated with him myself, and he just was extremely generous in his time and in his willingness to give me access to family files, old everything from birthday cards and letters to bar mitzvah albums to family mementos, photos, that sort of thing, which is just in like the rest of us, they're in boxes in his basement, which he hasn't fully gone through. And that was really invaluable to me. And of course, being able to interview him. He's someone who knew the judge well. I mean, he was in his 20s when the judge died. So it wasn't just, as a doting grandfather he barely knew as a young child. I mean, he knew him well and knew him as an adult. And thought a lot about his effect on the family, thought about it a lot. His own father had a rough time with addiction and with illness. And so he had reason to think a lot about sort of the larger profile of the family and how, his own father's struggles, fit into the family narrative, so to speak, with his father's father, with the judge. And more than just the access to the material and more than just his own reflectiveness, most important, he was willing to be sort of honest about how the family was, both the good and the bad. There's a lot of both, and he says that in the book. I forget exactly the verbatim what he said, but the gist of it was, I have a lot good and a lot good to thank my grandfather for, and some bad, to blame him for, is the way he put it. So he didn't, in other words, he didn't want a sort of hagiography of his family or his grandfather. He wanted an honest assessment, and that was great. But it wasn't just him. He has a cousin who was another grandson who was less informative. I spent less time with him, but he had some information. And then there was one daughter-in-law who was awfully useful as well. Who's a bit estranged from the family, actually, lives in Florida, and she was willing to meet with me and talk about her time, in the family, which kind of came when she married into it, and then left when she divorced. Well, no, I'm sorry. The son of Judge Kaufman, who she married, died. There was a divorce. The other one was divorced. But after that death, she kind of drifted away from the family. And then one last person, a sort of niece by marriage, I guess. But she was great because she knew people more of Judge Kaufman's generation, like his siblings, in other words. So right, all of which invaluable.
And then I know, I saw you speak recently at a bookstore here in New York, and one of the things that if I can ask, was there any hesitation? Was there any reluctance to sort of, you know, open the family history to you? Or in the alternative, I guess, why do you think they did that? It's you know, there's nothing prurient or inappropriate in what you were writing about, but still, these
Yeah,
were really family stories that were
deeply private,
being
sure.
told to the world. Mhm.
Sure, absolutely. And some troubled, history, and some stuff that no family, would want to go through, that they had to go through, some mental illness, as I said, struggles with addiction across a few people. So you're right. And I don't know that I have a great answer to that. I mean, I don't know why, other than just, approaching this, I think, in the proper spirit, which is recognizing that he was a historical figure, and that if you're going to write about a historical figure, we should do so honestly, with no hopefully no biases either way. And he just that was a project that he understood and approved of. And I'll say that I think that made him, ironically, since he's so close to the judge, a direct family member, that made him different from at least some other people whose connection to the judge was as a former law clerk. I mean, I did sometimes encounter in interviewing former law clerks a sort of protectiveness, even though, as I said, most of them had a kind of unpleasant experience, but there was still a lingering sense that, it's not right to talk about that. And yeah, maybe the judge had done, bad things A, B, and C, but that was in the confidentiality of chambers. And he always, especially among some of his sort of fiercest defenders who had been former clerks, which was a small minority of clerks, but there were 4 or 5 of them who kind of circled the wagons around him in the years, say, the 1970s and 1980s, when he was really under a kind of renewed attack over the Rosenberg case. So this overall defensiveness kind of grew up around him because he was under such scrutiny. And those few of his former clerks who had stayed close to him, who did really regard him with personal affection, were there to defend him. And I think that mindset, transcended, lasted well beyond his death. And many of those people, frankly, didn't talk to me at all, wanted no part of this project. I think because they assumed that, past examinations of the judge had largely been negative, and therefore this one probably was too, especially if it's a former clerk who may not have enjoyed his time there, so, but fortunately, the family didn't have that view at all.
Uh-huh. I know we want to sort of ultimately get to the question of, the relevance of biography, but
yeah,
I think we should do, we should do some more law.
Sure, yeah.
And some of the cases. And of course, you can't talk about Judge Kaufman without talking about the Rosenberg case. And I was really impressed in the book with, you really didn't get bogged down by it, if I can be, respectful of the case and the history and the significance of it, which was really, it was really, in the sense that, like the Dreyfus case, it became a political affair. It was much
Absolutely.
more than a case.
Yes.
Yeah. And so the thing I wanted to zero in on is, I mean, it was a controversial case as it was being tried. It was an even more controversial case as it was being litigated on appeal. For those who are listening and don't have a sense of the history, it's a very famous espionage case at the height of the Cold War, and involved the passing of atomic secrets to the Soviet Union. I don't want to, get bogged down on that piece, but you should obviously, elaborate as you feel necessary. One of the reasons why we talk about the case, we still talk about the case, why it is famous or infamous, of course, is that 2 of the defendants, the husband and wife, Julius and Ethel Rosenberg, Judge Kaufman sentenced them to death. And ultimately, after numerous appeals, they were executed. I believe the trial concluded in 1951, and they were executed in 1953. And so here's the question. What really seems to stand out today is, Ethel, that was a miscarriage of justice. What happened to Julius Rosenberg's wife, what happened to Ethel That is, Julius really seems to historically have, it's been established that he did spy or he organized the spy ring, but that Ethel was minimally involved, if at all, and yet they both were sentenced to death and they both were executed. So
Yes.
let me come back to sort of from the perspective of with Ethel, how and why did that come about, if I may ask?
Sure, absolutely. So the executions were 70 years ago this month. It's sort of an anniversary of that event. And you're right. I mean, so you zero in on Ethel. And why is that now more controversial? Well, for a couple of reasons. And we can sort of divide it up from what was known then and what was known now. So even in terms of what was known then, at the time that Judge Kaufman sentenced them, even given the trial testimony then, whatever you may think of it, it only minimally connected her to the crime. It was apparent even on the, even from the witness testimony then, that her relationship to the events, the espionage ring, and the specific transmission of atomic-related information to the Soviets was tangential. What she was accused of doing by her brother, who was also in the conspiracy, was typing notes describing part of the atomic bomb. It's the implosion lens, the lens mold. And David Greenglass supposedly came back from Los Alamos with handwritten notes and also a diagram. And the notion was that those had to be typed up so they'd be more legible to the Soviets, who they were going to be handed off to their Soviet courier, who was in New York City. And so, that's fairly low level involvement. It wasn't, she wasn't at Los Alamos. Obviously, she didn't understand the technology. She wasn't meeting with the Russians. She's a sort of, if you accept that testimony at face value, and we'll get to in a moment why you shouldn't, but at the time, accepting it, it's still not, not all that important. And that's it. That was really the only evidence. Now, there was some evidence, some sort of background evidence that maybe she had helped recruit David and Ruth into the party and into this effort. But that's really it. By all accounts of the witnesses at trial, not only both of the Greenglasses who testified, but a couple of other witnesses, Julius was the prime mover here. And so Ethel really suffered or sort of got the wrong end of a number of different factors. One, her lawyers did not present any sort of separate defense of her. And that was really tragic and unfortunate, because had she been separately defended by what we would today consider to be competent criminal defense counsel, that factor, the idea that she was not as closely involved, would have just been hammered home. So much so that the jury may not have, I guess the jury, the jury may not have convicted, knowing the jury knew full well that that it was a capital case, even though they were told repeatedly they weren't going to impose the sentence. But the prosecutors were concerned that, the mere fact that death was a possibility might result in an acquittal for her. The jury might have acquitted her to begin with. At a minimum, there would have been more front and center, I think, for Judge Kaufman to consider her as a separate defendant rather than just to consider them as a unit. What seems to have taken hold regarding Ethel is this stereotype of her, this sort of misogynistic stereotype of her as a controlling, as the person who manipulated from behind the scenes, even though there's no real evidence for that at all. But in his memoirs, Roy Cohn described her that way and described conversations he had with Kaufman where they both supposedly agreed on that. And that did fit a stereotype of communist women at the time. Alger Hiss's wife was portrayed that way. And so there was this notion kind of in the culture that if married couples were communist together, families were communist, women were communist, that they were steely and cold and domineering and controlling. That was the image of her, of Ethel. And she didn't help herself on the stand. She didn't do what's often expected unfairly, even to this day, I think, of female defendants, which is to show some sort of femininity or vulnerability or something of that nature. She sort of rotely denied the charges when she testified. She was didn't make for a sympathetic witness on her own behalf, unfortunately. And I think all of that, gave Judge Kaufman a sort of inaccurate or potentially inaccurate picture of her as someone who wasn't just a sort of appendage of her husband or even a controller of her husband, but rather of someone separate, individual, against whom the evidence was awfully sparse. So that's stuff in 1951 when she was tried. The greater reason today that it's seen as a miscarriage is that in the late 1990s, the main witness against her, her brother, recanted and admitted that the testimony he'd given at trial in 1951, that she had typed those notes, was perjured. And why did he do that? He did that to keep his own wife out of the crosshairs of prosecutors. He knew that his wife was as involved as Ethel, if not more so, and could easily be prosecuted on the same capital charges as she and Julius were being prosecuted on, and as he had been charged with. And he insisted to prosecutors that his wife be, quote, left out of it. And in exchange, under a lot of badgering from the prosecution team, Roy Cohn in particular, he implicated Ethel, which he had not done in grand jury testimony. So it was a sort of eve of trial, memory, so to speak, that shaped this testimony against Ethel that we now know is false. And so today, the only evidence comes from these sort of fragmentary bits and pieces we have from the code, the Soviet code, which the United States broke in wartime, and more revelations that have come out from Soviet archives in the 90s that don't answer the question, the degree, to what degree was she involved. She was a hardcore communist. She almost certainly knew about it. She probably approved of it. But again, to come back to being a lawyer, none of that is enough to be prosecuted for a conspiracy. You have to take an overt act.
Overt act, yes.
And
yes,
to
yes,
this
yes.
day, we don't know what, if any, overt act she took.
I think there's sort of two things, from the Rosenberg case that get carried forward. One is, he became a celebrity. The judge became a celebrity as a result of the case. And then, and this is really, I think, in some ways, the heart of your book is we saw, a different jurisprudence emerge from Judge Kaufman after his appointment to the Second Circuit Court of Appeals, the U.S. Court of Appeals for the Second Circuit in the early 1960s. And can you say a little bit, can you cover, 30 plus years, in 3 minutes? No, but just a little bit about those developments and what may have prompted them, because it's not, again, in the parlance of the law, it's not the most foreseeable outcome that
No,
would become on the Second Circuit.
That's right. It's not the most foreseeable outcome, and that is the sort of fundamental question I kind of set out to try to answer. And in the end, I'm not sure I have. I'm not sure I have the final word on it. Just to describe his sort of transformation a bit, what was really apparent in the Rosenberg case is a bias toward the government, and in fact, he conducted as controversial as the executions themselves were the revelations in the 1970s that he had ex parte contacts with the prosecution during the trial with Roy Cohn, with whom he had a personal sort of out of court relationship, like a family relationship with, personal friendship with. But that wasn't limited to the Rosenberg case. So all through the 50s, according to a later clerk of his who clerked for him, I think in 1959, he was doing the same thing then. So he just had this kind of bias toward the government, and he'd been a Department of Justice lawyer himself. That's where he'd risen to prominence. He was a protege of J. Edgar Hoover. He sort of took the FBI's good faith for granted, basically. And so all of that made him a sort of statist, pro-government, kind of Truman Democrat. Now, of course, the other side of being a Truman Democrat is liberalism. I mean, it's not to say he was that pro-government bias made him conservative in the 40s when he was coming of age politically, and in the 1950s after he was appointed. He was just a sort of statist. He viewed government as the means for the improvement in people's lives. And that's kind of apparent, I think, in that little clip I read from 1949 when he's appointed. He wants to make things better. He wants to use his judicial appointment to make things better. Well, that's the kind of classic mid-century Democratic view, to use government to make people's lives better. So what changed in the 60s and 70s is his evolution toward a more individual rights-based liberalism. And of course, he's not alone in doing that. He's following the Warren Court in that regard. The Warren Court is innovating across a whole range of areas in the law: criminal law, personal freedom, church and state issues, reproductive rights, spilling into the Berger era and Roe versus Wade, and poverty law, due process law, in all of those areas, liberalism, both political and liberals, transforming a bit away from a sort of bias toward the state and what it can do for people, and more toward minority groups and individuals who might even be adverse to the state in litigation or across other areas. So he's following that Warren Court transformation, but he's also pushing the envelope where he can on the district court, and Court of Appeals rather. One real example of that I found had to do with poverty law. The Supreme Court was kind of on the verge in the 1970s potentially of recognizing people of modest means or people in poverty as a protected class in equal protection cases and outside of that context as well. And Judge Kaufman approved of that. In other words, he would have subjected government regulations that worked against poor people to special scrutiny rather than simply rational basis review, which allows the government to do almost anything. And the Supreme Court came close to that in school-related cases in the 1970s and then sort of backed away. That was an example where he was kind of out in front of the Supreme Court. In First Amendment issues, he was out in front of the Supreme Court. For largely free press cases, he created a couple of privileges for reporters' deliberative processes, and for other aspects. There's the neutral reportage privilege, which recently came up in the Fox News Dominion voting system lawsuit, where you can't sue a news organization if they're simply honestly reporting the facts, even if the facts themselves are wrong. And those were both rejected essentially by the Supreme Court. So he's out in front, and to answer why, the leading theory was that he was kind of atoning for the Rosenberg case, that he wanted to stay in the good graces of elite, Upper East Side New York society, that he wanted to show the world that he was a good liberal despite what had happened to the Rosenbergs. I think there was an element of that to it, but I do think it ran deeper than that. I think his own experience growing up in poverty and in cosmopolitan New York, where diversity was kind of celebrated, honored, and a real part of the fabric of life. I think that played into his jurisprudence and contributed to why he became such a liberal in later life.
Yeah, I just have to add, even though, I teach administrative law, and while the Second Circuit is certainly not the DC Circuit, there's the immigration decisions, of course,
yeah,
which you write about the John Lennon suspending the deportation. And then even if you think of, a prison or a jail as an agency, it really was, I'm sort of, just articulating this as I think of it, but it was something analogous in some ways to the Charles Reich privilege-right distinction. That is to say, if the government undertook to do something or had the obligation or responsibility to do something, then he seemed really committed to, even zealous about it would perform those functions reasonably or properly. Yes. And there's one story about, you tell in the book, I think it's about a particular prisoner, where he was, dogged in bringing the agency right, to heal in some
Yes.
sense, in ensuring that justice in the case would come
Yes.
about.
Yes,
So,
I think that's because, I mean, you've hit on something else that really played into this, which I don't think gets enough attention when we talk about judges and why they do what they do, which is his personality. He was feverishly active. He was never passive. So when he saw an agency like that, like you were talking about, it was a state prison. When he saw an agency abusing somebody, and he wanted them to stop. In other words, he would not defer to their good intentions. He would not uphold sort of, amorphous orders that weren't clear about what they had to do. He believed in the power of the judiciary. I mean, the as you know, the leading sort of conservative variant at the time, and the sort of leading thinking in opposition to this mindset I'm describing was called judicial restraint. It's a phrase you don't hear that much anymore, because I think conservative, the sort of judicial conservative mindset has moved on to other things. But at the time, it was playing defense, and it was restraint against these activist judges who wanted the courts to run prisons and run school systems and run other aspects of city government, and kind of get their hands dirty and police the world. Well, Judge Kaufman had no use for restraint of any kind. he was active, and he wanted to use the power of his office to do things, and that's how it expressed itself. In that case you're talking about, he issued an order, the Court of Appeals did, that he thought would result in that prisoner's release. It was someone who'd been transferred wrongfully into a mental hospital, even though he really didn't have evidence of mental illness. It was really just punitive to put him in a mental hospital, and he languished there literally for decades, with other state judges and a federal district judge kind of ignoring him. By the time it came to the Court of Appeals, Judge Kaufman was outraged by that, and the court issued a mandate that should have, in his view, resulted in his near immediate release. Well, instead, the state prison dragged its feet and came up with other reasons to hold him, and not to get too bogged down in the facts, but the prisoner did certain things that didn't help his case exactly, and it eventually came back to the Court of Appeals. And by then, that was 3-4 years later. By then, Judge Kaufman was scathing. I mean, he was outraged that this instrument of government had ignored the court, and that's how he behaved across a range of cases. I mean, also by then, he'd seen, whether it was abuse in prisons, or he'd handled some cases where the FBI had done bad things, where he'd once been a sort of worshiper of the FBI. I think that plays into his transformation as well. By then, he'd been on the bench a long time. He'd seen a lot. He was a little more jaded and clear-eyed about government sometimes, and that influences jurisprudence as well.
So I think we have time for one more question.
Sure.
This is the big one, in the sense of, I call this question the relevance of biography question. And of course, you teach as well as practice. And having written this book and explored one judge's life in such detail, what do you make of the relevance of biography in understanding, the legal system, the development of the law or case law, and of course, in a common law jurisdiction such as our own, what judges decide, becomes the law in many cases?
I mean, you'll get differing views on this, of course. As I say in the book, in 1995, there was actually an academic symposium on judicial biography where they half seriously debated whether the discipline should exist at all, because could we ever really know what motivates a judge to do X, Y, or Z? And some think that's a fool's errand. So it's not susceptible to hard and fast proof, right, or quantification. I'm someone who does believe that when you confront these decisions that have a range of possible outcomes, a range of possible acceptable outcomes. So these are the hard cases, and of course, those are the cases that make it into a biography, right? Well, I'm not writing. He handled literally, I think, I was going to say thousands. I think that's probably accurate. In a 40-year appellate career, thousands of appeals. You can't get your arms around all of that. The vast majority of them were unanimous, non-controversial decisions. So most of what they do, we tend to forget, most of what they do doesn't really have a range of outcomes. They exist as the an error correction court of last resort for the vast majority of cases, and most of them aren't. They're not that difficult. But in that subset of cases that are difficult, where there is a range of possible respectable outcomes, I can't help but believe that a person's background, their experiences, their what's happened to them in the course of their life, their political views, which aren't directly relevant, but these days it's really been thrown into relief how there's a kind of parallel set of political views and jurisprudential views that kind of run in tandem together, such that in a person's political life, they're likely to gravitate over to a school of thought that leads to certain outcomes. And I think that's true on both sides. And I think that was true for him. It just seems obvious to me that the experience of growing up poor in New York, of living in this, incredibly varied, bustling city with everything going on in it, made him a more tolerant, broad-minded kind of person when it came later in his life, when he acquired this sort of seasoning that was necessary to see the world more broadly, that I think he did in what sadly is his most famous case, the thing he's remembered for, where I think he couldn't escape that biography.
Yeah. Well, I'm going to call it there.
Okay. All right. Thank you.
But thank you so much for giving us your time and sharing your thoughts about Judge Kaufman and your book. We'll of course have a link to the book on the Law Review site when we post the podcast. But for the editors, that's it.